81.
So what I was doing there was intending to summarise the criteria that are proposed that are applied within the area as a residential heritage area. The criteria are those in A. Items B to H should be called threshold test rather than criteria.
Difference B.
Dr. McEwan will explain that to you.
Look forward to that. Thank you. Okay. Sorry, you had another?
And the second one is at paragraph 89, Roman numeral 6. Second bullet point referring to Forbes Street.
Oh, yes. Yeah.
Now, I tripped myself up a little bit where I was trying to summarise the council position on this one. Prior to the words Forbes Street, please add in the following words. A submitter sought to exclude Forbes Street. Full stop. The council's evidence is, and then it continues, Forbes Street does have the requisite heritage value.
Submitter sought to exclude council's position as the requisite values are there, such that it warrants it, notwithstanding.
Yes. Yes.
Okay.
Thank you.
Right, so we have your subjects that you'll see this earlier, how we want to proceed that. So in your hands, are you planning to present with the full? How are you going to talk through it?
I am.
No, that suits our purposes, that's fine.
And he's happy if we have questions.
Please do, that'd be good. Yeah.
Yeah, sorry, it's our way.
You'll say to me.
Oh, sorry, just before you, sorry. This appeared earlier. With the all exclusions, put it that way. Yeah.
Okay. My name is Suzanne Richmond. I'm a Executive Advisor specialising in planning and the Heritage Team at Christchurch City Council. I have the qualifications and experience set out in my evidence in check dated 28 May 2035. I reaffirm that I am complying with the Environment Court's Code of Conduct for expert witnesses in presenting this summary of my evidence in responding to the submitter's evidence. I will cover the following in my summary: plan change for including recent decisions, summary of evidence, correction to evidence, proposed schedule amendment, removal of demolished 187 Fitzgerald Ave, response to submitted evidence, Daresbury Limited, response to submitted evidence, Series Limited, Series New Zealand, and I'm not actually quite sure when I think about it whether it's how to say their name, so apologies. Reference to submitted evidence, Otto Snot, and again there, submitter may need to correct me on my pronunciation.
I'm sure it's a question we'll ask her early on.
Translate was my only support there. PC 14 recent decisions. Since preparing my primary evidence, the PC 14 decision on Council's alternative recommendations was received from the Minister responsible for RMA reform on 5th of June 2025. On matter 17, the Minister declined the inclusion of a matter of discretion to protect the Papanui War Memorial Avenue's trees heritage item from the effects of adjoining intensification. As Council's PC 14 decisions on MPSUD are now operative in Policy 3 areas, and one of the new heritage items proposed in PC 13 is a site affecting capacity in a Policy 3 residential zone, and 5 are located in Policy 3 non-residential zones. I have made an assessment in relation to the qualifying matters against sections 77J and 77P at paragraph 5.110 to 5.117 in my primary evidence.
That's consistent with what we can. those evaluation matters and where they apply, where they don't apply. There's no difference between the two.
Right. Summary of evidence. Issue 1, protection of heritage items. I adopt the advice of Amanda O's in relation to scheduling of new items, having considered a number of submissions in support and some against, including for benches at Daresbury Bay and the Papanui War Memorial Avenues. As a result of submissions on Papanui War Memorial Avenues, I recommend some minor changes to the rules, which I believe improve the interface between the heritage and street tree rules. I also recommend a correction to the extent of the notified Sydenham Cemetery heritage item supported in the evidence of Amanda O's. Sydenham Cemetery received support for scheduling and submissions and no specific opposing submissions. I provided evidence for PC 14, paragraph 8.1.16, regarding the scheduling of Stradon Lodge, which is relied on in the PC 13 evidence of Marcus Langman, paragraph 45, and I continue to hold this view. Issue 2, removal of protection of heritage items. My recommendations to continue to schedule and amend protection for Daresbury setting, heritage setting, and Antonio Hall heritage item are supported by the other council experts. I address Daresbury again below. Issue 3, changes to protection. Based on the technical evidence of Amanda O's, I support reductions of the heritage settings of the dwelling at 27 Glendover Road and Rickerton Racecourse Tea House, and deletion of the demolished Rickerton Racecourse public grandstand heritage item. Further my discussion of these submissions at paragraph 8.1.74 and 8.1.75, I would like to clarify that the recommendations Amanda O's is making in PC 13 on these two sites are consistent with the IHP recommendations made on both sites in PC 14. Decisions on submissions for these sites were not made in PC 14 due to the sites being outside NPSUB policy approved areas.
So the panel addressed it.
So the panel made recommendations. I just thought I should point that out. Did make recommendations, but because they were outside policy 3 areas, the council didn't make decisions on those sites.
Right. Yeah.
We carried over. Issue 4 and 5, changes to religions. My evidence considers a number of submissions, both in support and opposing changes to the heritage rules framework. Based on my years of experience working at council with the district plan heritage provisions, heritage owners and resource consent applicants, and my daily observation of the implementation of PC 13 in the 2 years since notification in March 2023, I am comfortable that the notified changes have been working successfully to promote good heritage outcomes, with no resulting increase in resource consent numbers associated with the minor strengthening of rules and greater use of permitted standards. Now, I would draw the panel's attention here to footnote in my primary evidence, footnote 49, paragraph 8.1.93, which provides some more details on numbers.
So it's footnote 49.
So footnote 49, primary evidence,
Yeah.
paragraph 8.1.93. I consider that the changes proposed in evidence by Marcus Langman in the council submissions will improve the clarity and accuracy of these provisions. I am proposing a further change to the first part of the demolition policy in relation to heritage items to establish a policy position which ensures that the activity status hierarchy in the rules between the operative activity status for demolition of heritage items and proposed activity status for buildings and residential heritage areas is articulated in the policy, so the policy in turn gives effect to the objective. Equivalent changes to the policy to apply it to RHAs have been addressed by Glenda Dixon in her evidence. I have proposed a minor change to the notified wording of the heritage setting definition at paragraph 8.1.125 to further clarify that the heritage setting does not form part of the scheduled heritage item, which is the feature which meets the scheduling criteria.
So that's not a change in intent, that's just a clarification.
It's just a clarification. I have also recommended a change to the wording of permitted cemeteries rule at paragraph 6.1.20 to 6.1.28, noting that there were no submissions on this rule. This is to correctly reflect the intent of the notified rule as described in the Section 32 report, which is to permit all non-monumental works, which is more enabling than the notified reading of the rule. Issue 6, other submissions. I have made some recommendations on submissions on a range of general heritage-related matters. Issues. Corrections to evidence. I would like to make a correction to my primary evidence in the out of scope submission section of paragraph 7.1. Yes, this paragraph was followed. It is out of order and should follow paragraph 7.1.7 as it relates to the further submission by series limit. Series limit. Post schedule amendment removal of 187 Fitzgerald Ave. Resource consent RMA 2023-325 was granted on the 3rd of October 2023 for the demolition of the scheduled heritage building at 187 Fitzgerald Ave. As this was subsequent to notification of PC 13 in March 2023, the deletion of this heritage item number 641 and heritage setting 376 was not included in the notified proposal. There were no submissions on the site, and so there was no scope to recommend removal of from the schedule in my PC 13 section 42A reporting. As this building has recently been demolished, however, and a new development is currently underway on site, I recommend that the heritage item and seating protection is removed now so that resource consent is not required for future works within the heritage setting.
Find out what that building was.
So that was a two-story timber shop, and it was, I believe it used to have, well, it did actually, because I went into it, residents on top. So
That's right.
and so now that's where townhouses are being built here.
So no submission, no scope to deal with that.
No, but I thought I'd put it forward because it suddenly struck me that it could be, it's very much along the same lines of the other deletions that we notified. However, obviously because of the timing, we couldn't, it hadn't happened at that stage, so it wasn't notified.
Well, that might be why we received a bit of guidance on. Look, I understand the context of time. It's just
And then I was a little bit concerned that there might be several years, don't know how many years, current context of a further plan change, and it would remain. And we've had issues with other sites where the building's been demolished and resource consent's been required. There's no heritage values left on the site. It's a clear site, and resource consent has been required for a new building in the setting, which doesn't make a lot of sense.
Yeah, I just, well, legally, what we're told, I understand the circumstances.
We'll address that.
Response to submitters' evidence, Daresbury Limited. I have reviewed the submitters' evidence of Jonathan Cleese, planner for Daresbury Limited, who relies on his PC 14 evidence, and have noted the letters he has attached as Appendix 6 and Appendix 8 to his evidence, which contains similar content to each other, summarising the submitter's legal submissions seeking descheduling of Daresbury. The discussion on Daresbury in my primary evidence summarises my opinions on the evidence of council and submitter experts, and includes consideration of Captain Tripp's letter to council. I remain of the view, based on my own assessment and relying on the evidence of council experts, that Daresbury can be retained as a highly significant item on the heritage schedule in accordance with scheduling policy 93221. I concur with Mr. Fulton's primary evidence for PC 14 at paragraphs 68 and 69, which are attached to his PC 13 evidence. See link in the footnote I've got there. These are all live links, which neatly sums up my view. So I repeat this in part here. Daresbury is of such significance both locally and nationally that it is reasonable to do what is feasibly required to strengthen and restore this building. The cost of repair of heritage buildings of the nature of Daresbury is significant, but is proportional to the scale of the project and the heritage value placed on the building. While I am not an expert in the detailed costs, I believe they should be compared to projects like Otahuna Lodge or Mona Vale, rather than domestic projects of similar scale but lesser heritage value.
Good question. I can't recall Mr. Cleith's discussion around consideration of reasonableness at the time of this. It certainly raises it, and we'll probably, I suspect, hear more about that today. Certainly in his latest statement of evidence. And criticism, if you like, or that way around how that's been interpreted and applied in the context of Daresbury. I appreciate the quoting from Mr. Fulton here, but in your view, is that reasonableness consideration encompassing of all sorts of things beyond cost, including what Mr. Fulton refers to here as an overall value appraisal versus against financial impediment, if you like? If I put words in your mouth, but is that the intention in terms of how you would apply and interpret reasonableness?
Yes, I think that it's very broad and there's a whole lot of factors, and there are a whole lot of factors in relation to not Daresbury, but also relevant on sites where buildings proposed. In terms of building, it's building specific issues, but also owner specific issues, site specific issues. I mean, there's as has been introduced in my evidence and the other experts' evidence. There's complex factors, a lot of factors to weigh up.
And my question really is, that's legitimate to do so in the way that has been interpreted and applied holistically, I guess, across the whole plan change. So setting aside the specifics of this particular property, when you've been thinking about things like reasonableness, the criteria or the matter of reasonableness, that's been something of a qualitative and quantitative appraisal.
Yes, it has. I've tried to apply some principles across the sites, but obviously you also need to look at what the specifics of the site and the owners as well, and then thinking about, of course, Section 6F, purpose of the Act as well. So there's a lot of factors too, and weighing up costs and benefits into account there.
Yeah, great, thank you. That answers my question. We may need to explore this further. Well, as I said earlier, maybe that happens tomorrow, just given the sequencing of these things.
Okay, response to submitters evidence, Series New Zealand. Mr. Individual Plan of Series New Zealand claims that the threshold test for non-complying activities in Section 104D is impossibly high for significantly damaged buildings. Points to other examples of site-specific rules for the Christchurch Cathedral and Taylor's Mistake batches, and recommends that a significantly damaged building schedule and associated more permissive rules framework would better meet the purpose of the Act. As discussed in the section of my evidence on provisions for significantly damaged buildings, and also discussion on the demolition policy, I disagree that not having a customised rules framework for specified significant damaged buildings makes it substantively harder for owners to deconstruct these buildings. I'm not sure whether it's supposed to be substantively or substantially. Heritage Objective 93211 and Demolition Policy 93228, as amended by PC 13, are targeted at the most significantly damaged buildings and other buildings which are in poor or unsafe condition. These are the buildings that may be able to meet clause A3 of the objective. In some situations, demolition may be justified by reference to the matters in policy 93228.
Sorry, it's just keen to interrupt you there. So your interpretation of perhaps the policy, objective of policy pathway under 104 is not foreclosed in the way that John would suggest. Setting aside fix the gateway around objectives and policies that not being contrary to is not closed, your view? Which seems to be what Mr. Jones is. He's saying we've got a gateway test under 104D, one related to effects, one related to the policy framework. Setting aside effects, I guess I'm interested, given what you've described around the objective unaltered and the policies as recommended to be adjusted, still leaves live the option of a not contrary or not being contrary conclusion around the demolition proposal. So demolition of a building could still be found not to be contrary with those objectives and policies framework in your view. Is that what you're saying?
Sure, yes, there's absolutely the ability for it to be not to be contrary or to be consistent. Yeah, and I go on to say there have been instances. There have been instances of being consistent with.
That was my next question.
Yeah,
in terms of the years of experience you've had, in terms of the scenario, is that played out to be true around determination under 104D that there has been a gateway pathway open in the case of a demolition of a building?
Yes, so I'm coming to that.
Okay, sorry.
Can I just ask there what your view is in terms of if the additions of the word avoided were possible?
So we.
So in the same framework, but we're talking about the additional wording that's been proposed. I can't.
So the demolition policy, we're talking. Yep.
Yeah, I've got some questions on that too, actually.
Okay.
That.
No, it was just, my question was just in terms of whether your view on the gateway test would alter if those words were put in, the words being retained or retained where possible.
So what I was proposing was to be avoided wherever possible. Yeah. I mean, the policy I feel has been working till now, as I've sort of implied in my evidence. The addition of the words is partly to balance the residential areas have been proposed to be brought into the policy. So to make sure that the wording was equivalent, but it would be helpful to actually put a policy position in there. And so it has been operating without that that clarity to be avoided wherever possible, in the case of highly significant heritage items. The operative policy has been working fine without that, but I think there's some benefits in terms of clarifying the outline of giving people the objective and linking and with the activity statuses.
Yes, that was part of my question, was on the experience to date around having to apply 104D. I think I heard you correctly that there have been circumstances where the gateway around objectives and policies has been found to be opened on the situation of demolition, notwithstanding, even without the recommended word change. So that's as worded currently.
Yes, I'm just thinking about the timing of that. In my next paragraph, I'm going to mention what's in race course public grandstand on that. So yes, that was part of notification. Yeah. Yes, so that will make sense at the moment.
Okay. If it doesn't, I'll come back to you. But
well, I hope it will.
Thanks.
Yeah. Demolition applications processed by council show that it is possible for proposals for demolition of significantly damaged buildings, also buildings in poor condition or unsafe, to be assessed as minor or not contrary to the of operative duties and policies. Brixton Racecourse Public Grandstand application prepared by Mr. Joel is the only full demolition application lodged for an earthquake damaged, highly significant scheduled heritage item since the Canterbury earthquakes. The decision records that the primary drivers for demolition were the scale of the costs of upgrading the structure and the significant constraint from reuse. The proposed demolition was assessed by the Commissioner as being consistent with objectives and policies. In this case, a highly significant item met the threshold test for non-complying activities without damage being the most important or only factor.
Should have wiped it. That's helpful. Thank you.
Three of the resource consents granted for demolition of significant scheduled heritage buildings, which were notified for deletion in PC13, were granted on a non-notified basis. Essentially because after taking into account their condition and required repair methodologies under demolition policy, there was not an identified repair option that would retain the integrity and heritage significance of the heritage building. I'm not generally in favour of site-specific rules, as while they may seek to provide clarity for certain sites, in my view, in doing so, they risk unfair outcomes for other sites and can make the overall rules framework more complex. I did not prepare evidence for the Christchurch replacement plan hearings in 2016 on the customised rules for the Christchurch Region, which I understand came into the plan in response to the owner's submission. In relation to the proposed committed law for the Daresbury state batches, this only applies in the narrow circumstance where a batch of license to occupy is cancelled, and I consider there are very unusual site-specific factors which justify the permitted law in that case. In response to the matters of discretion Mr. Joel proposes for significantly damaged buildings, I consider that engineering costs and threat to life property are provided for in the notified demolition policy. Salvage and interpretation are standard conditions of demolition resource consents along with photographic recording. Consideration of whether consent has been granted for a replacement building may provide some mitigation in broader urban design terms. However, when assessing impact of demolition on heritage values, a replacement building does not mitigate the loss of a heritage item. I agree that the assessment matter Mr. Joel proposes relating to whether a Section 124 Building Act notice for dangerous or unsanitary buildings has been issued in relation to the site is a relevant matter to consider in demolition applications. And I would add that whether the building is entered on the National Register of Earthquake-Prone Buildings, the EPB register, is also relevant. However, I consider these are both engineering factors which can be contemplated in amended clause number A to B, capital B, of the demolition policy and the objective in relation to the condition of buildings A2. And I consider these are appropriately provided for already under the operative consent status for the building. I consider that the various complex factors relating to the feasibility of retaining or demolishing significantly damaged and other heritage items in poor or unsafe condition are either directly related to the condition and heritage values of the building itself, or are wider, less directly related but equally valid considerations which might be site or owner specific. In my view, these are more appropriately assessed via a discretionary or non-complying activity status or associated policy findings, rather than seeking to derive an exhaustive list of matters of discretion for a restricted discretionary activity. Mr. Joel considers that the addition to the demolition policy of the wording is to be avoided wherever possible, particularly in the case of highly significant heritage items, represents a significant policy shift that should have required a Section 32AA assessment. As discussed in my evidence, the amendment does not seek to change the policy approach, but to articulate a policy position which better gives effect to the objective and is already implemented in rules for operative activity statuses and the existing list of facts in the policy. I disagree that the words wherever possible are subjective. as these words are placed to directly acknowledge the list of existing considerations which follow in the policy, to inform a conclusion as to whether it is possible to avoid demolition or demolition is justified. In my view, the proposed demolition provisions are the most appropriate way to achieve the purpose of the Act.
I'll just ask a question around the wording, your understanding of wherever possible. So, as I'm reading this, your evidence is that the wherever possible interpretation, necessary a subjective one, is informed by the list of considerations of the policy itself. So, why I'm asking that is my layperson's hat on. Many things. In fact, most things are possible. Very little might be deemed to be impossible. But what you're telling me is, in this context, possible is an interpretive matter around those particular policy matters. I haven't even in front of me, but that's
Yes.
so there's some clarification around how you would apply the term possible, not is in the policy itself, right?
Yes.
Okay.
It's acknowledging that there, with reference back to the objectives as well, that there may be not in place. There may be situations, some situations demolition may be justified. So recognising that it's not always possible.
Sorry, didn't look at this.
Sorry.
Did you mention the word you just was that the
Sorry, I'm quoting the objective. So in some
Okay.
situations, demolition may be justified.
I'm less troubled by the objective. I'm more because you're talking about the policy as informing what will be possible and not.
Yes, and my thinking with using that wording was that it was acknowledging that the following list of circumstances which need to be considered and may result in a conclusion that it's not possible.
Yes.
And just for clarity, you're saying that's objective. That's an objective test rather than a subjective test.
Obviously, it's relevant to the person doing the assessment, but the idea being that that the policy sets out a list of matters. So in that sense, it's objective because the matters are constrained.
There's a definitive
It's a
list.
definitive list, yes, that's right. But then, of course, it's open to interpretations and try from a staff perspective, attempting to be really consistent in how we interpret those matters.
Okay, sorry.
So, response to submitted evidence by First Snob. And finally, I respond to submitted evidence from Mr. Snob on the Taylor's mistake batches. I hope he's not cringing at the way I pronounce his name. In relation to Mr. Snop's discussion on existing use rights on page 1011 of the submission, I note that district plan heritage protection and associated rules amended by PC 13 mean that where a license to occupy remains in place, resource consent is required for removal of the batch and for alteration in cases where existing use rights do not apply. Aside from regulatory consenting requirements, heritage protection is also an education tool for working with owners to support changes which maintain the integrity and authenticity of heritage items and retain heritage significance. As noted in the statements of significance for the batches have often been altered and adapted to suit the changing needs of owners, and this forms part of their significance. Amanda Owens had responded in her summary to Mr. Smith's comments on the section 32 analysis in relation to the statements of significance. Contrary to Mr. Snop's assertion on page 19, 16, 17, I consider that the heritage feeding of the batches is not inconsistent with Chapter 18 open space policies and rules in the district plan. And the open space coastal zone rules in 18.9 provide for the existing beaches at Tasman State Bay. In conclusion, other than where I have stated, I continue to hold the views expressed in my primary comments.
Thank you, conceptually. Questions? Moment. Yes.
No, just while we're waiting for the pregnant pause. Just in terms of the Princess Margaret and the discussions we've had relating to that, you addressed that in your paragraph 1.18, relying on Ms O's evidence. It's funny from your perspective, a lack of available financial and engineering information. From your perspective, is that, in your view, appropriately a relevant issue, that there's a lack of information?
Well, we are very conscious of needing to consider the policy, utilizing policy carefully in terms of the exemptions, if you like, for engineering and financial reasonableness. So where we know, where staff know that the building hasn't been repaired or is hasn't been upgraded, or that, you know, we suspect that there's information out there, or then we would like to see that. We would, in order to inform our view on the scheduling. So we in that case, it was clear that the building wasn't in use, as I understand it, and that there would be reports that could be made available to us, and we'd want to have as much information as possible to inform. We wouldn't want to be scheduling building where that information was out there and we hadn't considered it.
Can you just point me to the just have it in front of me, but in terms of the policy framework with that, the scheduling.
So the scheduling policy,
Yeah.
the C 93221 policy identification of assessment and scheduling of privilege item, and C, so they meet the threshold in period significance, and then C, so they meet the threshold unless same copy I have, you have to turn over the page to C3 and C4, those situations that might preclude scheduling in terms of physical condition, engineering and financial. For instance, 321 C3 and 4.
Okay. Right, so it's for the engineering is related to the physical condition of the heritage item. make unreasonable approach. That's in 4, as you've pointed out. And the physical condition in C3.
Yes, essentially, the rules will retain a significance.
Can I just, well, it's in front of me, can I take you to paragraph 7.1.8 of your primary evidence? With relation to the submission, submission of the evidence. Joel, we heard from Mr. Busy this morning that his submission to us is that the suggestion around a different activity stage, like controlled stages versus restricted discretion, I think it was, it is within scope for us to consider. And in your evidence, I think at paragraph 7.1.8, thereabouts, you dismiss it as not being within scope and don't address it further.
That was the one with the correction.
Okay.
Where, not like I didn't address it further, but in 7.1.11.
That's the out of order sequence.
I do address it further.
So
yeah,
nothing's changed in respect of that other than putting the paragraph in the right
That's
place.
right.
Yeah, okay. Can you explain to me what you understand how buildings that are deemed to be significantly damaged would be identified and therefore included in the plan by way of appendix, which is, I think, the construct that Mr. Joel
yes.
outlines in his evidence. I'm unclear as to what defines those buildings,
Yes, well,
if anything, at this point.
You may wish to ask him.
I will.
From my perspective, I'm pointing out that there are other reasons other than significant damage,
Yes.
condition, building being unsafe, and those other factors around dangerous and centric buildings, earthquake prone, buildings that have been neglected, and they might not be qualified as being earthquake prone, but they're in poor condition. So there were, it would be very difficult, in my view, to pin down a list.
We'll ask.
But I mean, I'm not obviously not impossible, but yeah, difficult because it's sort of a moving feast as well, because we're not easily aware of the condition of every single building on, or we aren't, to be fair, of every single building on the schedule. I mean, we have a lot of contact with owners, but not every owner, and so that would, and also maybe most buildings have been repaired, some haven't been repaired, and that, so we're talking about this earthquake damage, but also buildings that are left in poor condition, and then where is the line in terms of neglect, just sort of deferred maintenance through to demolition by neglect sort of situation. So it's a continuum, and I would think it would be quite difficult to draw a line around a group of buildings.
And that difficulty is part, if not all, of the reason why you disagree with or don't support that request for change.
Yes, partly, and so explain my evidence as well. I believe that these framework, current framework is what they use, is actually focused around those buildings, the very buildings that are the most damaged, the poorest condition, and those are the ones that may actually meet the policy. And it's the, as I think I said, the intact buildings that are not so in such poor condition that are not actually going to meet those policy.
Yeah. So there's a policy pathway currently in your submission. there's some challenge or difficulty or ambiguity or uncertainty around what would or wouldn't qualify or should or shouldn't for recognition if there was. I think the third dimension you identify as your support for bespoke site-specific identification or collective specific collective identification in the case of the batches
Yes.
in very limited circumstances. Yes. I'm putting words back at you, but those three are contributing elements to
feel
why
like there needs to be a very, very particularly site-specific reason for having bespoke rules.
You talked about demolition by neglect. Is there anything in the plan that addresses that or assists?
No, it's a very long-standing national and probably international issue that we've grappled with over many years in terms of how that could be expressed in the plan, or that there's other non-regulatory ways of going to support owners, such as funding or other support for owners outside of the plan, which possibly could be more effective than making people maintain their buildings. As we're sort of harking back to the owner support issue, we want to the council staff. When I say we, sorry, I mean heritage team staff. Like to have the support of owners, because if they're not supportive, then it's unlikely that they're going to want to maintain the buildings and work with the council staff to support changes to their buildings. So if they're resistant, then it's difficult, as I said as well, in terms of getting access or getting information from the owners if they're not willing, but also they're unlikely to be motivated to support appropriate reuse and retention and maintenance of their buildings. They don't want them protected in the first place.
Doesn't the approach, certainly the wider approach, in terms of the owner buy-in, etc., doesn't it more or less benefit people who choose not to, if you like, because you're saying, well, we haven't got the information. So you're benefiting people who choose not to engage, potentially.
Yeah, I'm grappling my mind with this. Yeah, merits per se, heritage protection is justified or not based on applying the methodology, and then there's an adjunct, which is, well, setting that aside, unless we've got support, somehow that's trumped.
It's a very pragmatic.
Yeah, I've heard that. I'm not
We've taken
evidence, but really like some guidance around what that. I think I've already asked you around what that means in the Section 32 sense. I'll probably leave it there.
Yeah, almost here it fits in with Section 6 matters too.
Yeah. I mean, I get that the motivation, Section 6 is actually important. We'll go down to the apply methodology. We'll identify on the facts, on the value, or accepting that there may be situations where that's a complete because of access limitation or whatever. But where you've got that information and it's a sound, robust assessment, and then all of a sudden that is trumped by the fact that there might not be the current landowner support for that. I'm interested to know to what degree that is a relevant and material factor when we're looking at the effectiveness and efficiency of the policy and provision.
It's weighing up those costs and benefits, isn't it? And so there's the cost to the landowner when we're taking that into account.
Sure. Yeah. No, I'm not predetermining the outcome. I'm just interested to know how those two, how you reconcile that. I guess.
This isn't the only part of the plan where the issue arises. It arises in relation to ecological areas, as an example.
Maybe I'll lie in relation to trees. I don't know what the methodology will say. I'm sure it's not unprecedented. But all I guess is I'd like some directional guidance around how we view that legally.
Can I ask you to walk me through your paragraph 12 for letter 8.1.125? Primary evidence in regard to the minor change for the setting not being part of the heritage.
So if you could please repeat that reference.
8.1.125.
Oh, 125, sorry.
Relationship between the heritage item and the setting.
Just find my colour version of any provisions, and you might be helpful if you just say what was proposed in notification and the change. Here we go. Right, so I'm now looking at the provisions, the colour coded provisions for here at setting. So the question was raised in submissions in PC 14, suggesting that the now struck out in purple sentence is a bit unclear. Here is settings not being assessed as meeting significant threshold for scheduling and may include doesn't make sense unless you but essentially there was confusion identified there. The intention was to point out that settings as it says in the first part, integral to the contextual significance of the heritage item. They don't stand alone as meeting the criteria scheduling on their own. And so it was just trying to improve the clarity there to explain that settings don't exist without the item. By definition, they are they form part of the value of the item, but in terms of the outline, the mapped outline, it's the item which meets the threshold, and the setting is the context which has its own protection and own rules, but it is subsidiary to the item.
I think I understand where you're coming from. What I'm not quite clear about is to add the sentence, the heritage setting does not form part of the scheduled heritage item. I'm wondering if that makes that clear, because it is part, as I understand from what you just said, of the heritage item. It actually contributes to the value of that item.
Value-wise, yes, but in terms of the protection, the item has an outline around it, and then the setting is a separate outline, as you see on the heritage aerial maps, and so that it has then different rules associated with it.
So, do I understand you right that the setting in that respect is not like a part of the building, like the roof?
The curtilage.
Yes,
That's right. It could be the curtilage. So more often than not, it's either, if it's a big site, it might be part of the site, might be the setting, with giving the immediate context around the item, which of course is not always a building. It might be a monument or so forth. But the setting could be part of a land parcel, or quite often it's the whole land parcel. And generally, we don't recommend this is part of the affecting other parties situation, where we would generally stick to the land parcel and not go beyond, unless it's in the same ownership.
Title boundary, in terms of legal definitions.
Yes,
That's right. Yeah. Okay.
But the settings do have separate rules in terms of their protection as a element of
buildings within the setting, and earthworks rules as well.
Is it only while the item itself remains?
Yes, exactly. Because if it were if it met the threshold, then it would be an item. But so it's basically indicating that in some cases, generally that is how it is approached. That it doesn't meet the threshold.
It's value because there's a heritage item in association with it, even though it might be separately identified. If you know.
It's tied to it.
And the setting loses substantially or significantly, presumably, without that item present. So thereafter, should the heritage item be demolished or removed or somehow modified dramatically, that has a bearing on the relevance of the setting, whether that setting should remain.
Yes.
Therefore, works occurring in that setting after a heritage item has been removed are less restricted.
I mean, sometimes the settings do have values, of course, but I'm talking about a situation like 187 Fitzgerald where the site has been completely cleared. If you remove the item from, you could have an intact setting that can still have values, of course. Yes.
And if it's standalone, but inherent values as such, should identify that setting as an item in its own right.
That's right. It could be assessed along the lines of what Heritage New Zealand was seeking in their submission, which was about taking the opportunity to reassess the setting. And I made some comments there around, yes, potentially a setting could be reassessed as meeting the threshold, but generally speaking, what's happened is it's been assessed already as contributing to the significance of the item, but not meeting the threshold in its own right. And so that's why, by virtue of that, that's why it's a setting, not an item.
That's necessary reality anyway. I mean, things will evolve, information will come to light, information that was once relevant now has less relevance because of what's happening.
That's right. So it's not impossible. We're not saying that, information can come to light that it's, which may indicate that it could meet the threshold. But, and as I've said in response to Heritage New Zealand's submission, that, I mean, absolutely, it might be possible for a setting in the future to meet its intent, and this is now something for Ms. O's to respond to again in terms of talking to about heritage values. So I'm not going to stray too far into that. It could be reassessed, but in principle, it could be reassessed in the future. However, that would require a plan change.
Yeah, I'm still trying to think of an example which would aid well before your time. I mentioned was the Edmonds building, for example, on Ferry Road.
Not that long before, but
Before me.
Yeah.
Well, we don't.
It's got real heritage value. It's yeah. So the Edmonds factory was off Ferry Road, obviously, in a substantial building. And associated with that were the rose gardens. Yeah. So does that have with those rose gardens? They may in fact have a status of their own as an item.
that's a great example. That's a great example because that has met the threshold. So that's right. We're not saying that it would never happen. It's just that I was using an example of a clear site that where there weren't any tangible heritage values left, in which case we'd remove the setting. We'd seek to remove the setting.
Can I ask you when page 68 is? Sorry, that roughly.
I couldn't.
I'm standing at the
Actually,
looking out. Left or right?
I couldn't tell you, to be honest. I do have a wee map here, which might happen to be on it.
Look, don't need to tell me now, but at some stage the next episode, because I'm just confused where it was. You picked it up at paragraph 8.1.26 of your evidence, so I just was trying to visualise. I've been there, Edmund, but I don't know any particular questions.
So it's an operative. So in the schedule, the operative schedule. I mean, I can pull that out for you, obviously, but just so you know where it is, in the operative schedule, there's links to the statement of significance.
Yes, I can probably find it.
Well, I mean, I can. Would you like me to retrieve it for you? Yes. Yes.
Yeah, I've got the various questions. I mean, you've answered. I was interested in reading your evidence and then receiving the evidence with the cleans around, contrary view, if you like. around what underlies those essential differences. I'm leaning towards hearing from Mr. Cleese this afternoon or wherever we get to it, but I think it'll be later today. Very much with the expectation that I might come back to you, having heard that. I know it's dangerous to go into an iterative circle, but you've said what you've said in your summary statement about having read this evidence. I get that. I'm pretty sure there may just be nuances out of this presentation that I would like to get earlier with us. So, your availability.
Okay. I'm just trying to find the relevant paragraph number in your evidence, which I frankly didn't do when I was doing the preparation, but the Pakenui War Memorial and the matters that have been identified by Ms. Elvidge in her submission. Where do you address that? I'm just trying to think.
It's on that, yes. So probably one more news discussions about paragraph 8(1)(29) and the response to the minutes that's at 8(1)(31).
So and your recommendations is that inclusion of identification of that includes the avenues of trees, parks, and adjoining road reserve to make that clear. But in terms of the impacts that could have on earthworks and similar issues which were raised, you addressed that, and that's in your 134, isn't it?
Yes,
Yeah, the works within 5 metres of a heritage item.
yes.
And the impacts that.
I'm not sure if I've seen in there or not, but some works like underground services and so on, placement of permitted under the maintenance definition. So that those don't have consent.
Do district-wide rules, utilities, others that have wider application trump any of the heritage? It might be a question.
They actually work together as from my they anticipate heritage and the fact that utilities rules. Interesting that they have been considered at every turn. Heritage, and there's some rules in there around.
Look, I haven't gone back and I appreciate that those rules are the subject of the plan change, but the interrelationship of those sometimes there's a
that has been considered in every
prevailing provision or something in those district-wide ones that might have the circumstance of a utility, for example, render these rules secondary, if I put it that way. Same with the protected tree rules. I don't know how that relationship works. You talk about it here. Sorry, I'm delving into an area I said I confused myself on, so I won't pursue it any longer. Yeah, it's a generic question in the sense that the interrelationship of rules that aren't subject to the plan change but have a bearing on how these rules are applied is something of interest, I suppose, to be reminded for us.
Yeah. So you addressed that in 8.1.35, your comment on that, the significant and other trees, chapter 9.4. Yeah, so just explain to me your recommendation in 35 again, in 8.135, so I'm clear of what you're actually saying.
Okay, so essentially trying to tie those chance to talk to each other. So turn over to H127. I'll see out the there.
Okay.
And it's probably, I don't know if it's covered there, but.
Yes, it is.
Yeah, I've managed to print mine out in black and white. So lots of the provisions which have all the rainbow colours in there to show what I'm proposing. Some fairly minor, changes there.
Because that's
So that's the item that the pruning and maintenance or remedial work would be permitted. Felling big trees. Cross-reference there saying that they P6. And this is in the trees rules, yeah. That with the heritage items, heritage rules, and likewise earthworks refer to the heritage earthworks rules, which are in the earthworks section, not in the heritage section.
and these are like essentially in response to the submission, I think.
Yes.
Okay. Right, thank you.
That's it. Come in. The questions down a little bit. Just keep what you're getting yourself service. Sorry, I've turned to my right of the gallery. Is there anybody sitting observing there speaking to you today? No. No, okay, tomorrow. Yeah, fine. It's my expectation. I was hoping it was yours.
Or Friday.
Won't be Friday, I'll be every year on the way to Perth. Put your hands. You've got a summary statement, have you? Yes. Through there. Thank you.
My name is Dr. Anne McEwan. I'm an architectural historian and the principal of Heritage Consultancy Services. And my business specialises in built heritage identification and assessment for district plan reviews and plan changes. And I've also prepared numerous heritage impact assessments in support of resource consent applications for scheduled heritage items and areas. I prepared evidence on behalf of the Christchurch City Council to assist the panel in matters relating to the RHAs and a number of potential scheduled heritage items. I reaffirm that I'm complying with the code of conduct for witnesses. My evidence in chief describes my identification and assessment of 9 residential heritage areas in Christchurch City and Littleton. I outline the background and methodology I applied to the proposed RHAs. I provide my view on submissions in respect to 6 of the proposed RHAs. The other 3 weren't subject to submissions. And I also discuss a number of potential RHAs, which I assessed but did not recommend for scheduling. Finally, I address a number of individual heritage items about which the council asked me to comment. My evidence notes that the RMA and the RPS anticipate and provide for the identification and protection of heritage areas, which should proceed from such areas, quoting from the RPS, importance to Canterbury's distinctive character and sense of identity. I also explain the distinction between heritage and amenity or character values and identify the importance of the post-earthquake context for the identification of PC13 RHAs. If I might, just to reiterate what Mr. Fizzy has just reported, In his legal subs, para 81.
81, yep.
This was happening after the lunch break, because I had spoken to Mr. Bibby during the lunch break. At para 81, he clarified for the benefit of the panel a little while ago that 81A summarises the assessment criteria. 81B, C, D, E, F, and G, and H, he referred to them as the threshold test. And that I would also describe that as the methodology, if you will, for determining a recommendation to schedule. So that and the assessment criteria, which are summarised at 81A, they are in the operative plan now at Appendix 9.3.7.1. And those criteria ultimately hark back to both the regional policy statement and the definition of historic heritage resources in the RMA. The thresholds, B through H. In the operative plan, there are thresholds for individual items, and Ms. O's referred to those, and they can be found at 9.3.2.2.1. Planning. And so the way I would characterise what Mr. Pizzi has presented to you is akin to a two-part kind of practice and policy for heritage areas. The operative plan already has the same approach for heritage items.
Question related to how you, given you've identified a distinction between the criteria, thresholds, and methodology, or something to qualify, is it important that all of A through H exist or are satisfied? Or is there a priority at a beginning or something like around A being essential, but some of the others not necessarily being so? I'm not, yeah.
The items and areas have to meet the criteria.
So A is a given.
A is fundamental,
Yes.
foundational. B through H are they're the kind of practice note almost, or the guidance for what to consider as you work through those assessment criteria.
But aren't hard and fast. For example, let's take H. Say there's 14 properties, not 15. Everything else is not a fatal flaw.
No, and I think one of the things that the panel has, if I may, we've heard about 25 Taylor's mistake batches, and potentially that could have been a residential heritage area. So the RMA and the RPS both allow for items and areas, but they don't. The RMA and the RPS don't sort of say this is how you will know one from the other. So it is a matter of implementation and interpretation, how councils then assess those, establish those things. So potentially and Taylor's mistake is a good example of where you might schedule everything individually.
Yep.
In my opinion, it would be equally valid to have said that was a heritage area because the criteria are met, and then it's a question of practice. What do you do about that? And the checklist, if you will, or the methodology that Mr. Pizzi has presented in B through H is a kind of a benchmark or it's a threshold test. I think that's a useful word to be sure that you haven't kind of.
Yeah, I'm not too trouble with the semantics. I'm more interested in how you what it means. I mean, we're putting labels on things that don't necessarily need it, if you know what I mean, for the purposes of our decision. But understanding how they're applied is important.
back to my para 5. For clarity, although the Heaton Street RHA was withdrawn by the council, my reference to it at paragraph 55 of my evidence in chief remains valid, I believe, to the extent that the RHA identified included only part of the total length of Heaton Street, and that is an issue with some of the RHAs, because the eastern section no longer possessed sufficient authenticity and integrity. I could have referenced the McMillan Avenue RHA to make the same point. And I also note in that paragraph 5 that I acknowledge that I incorrectly referred to Dr. Anderson instead of Dr. Adamson. The council resolved, as you've been told, the council resolved on 4 June to remove a further 24 properties from the Littleton RHA, and I was the one who identified that those could be deleted without a notable impact on the heritage values of the RHA as a whole. Since I prepared my evidence in chief, I've reviewed information provided to me by the council in respect of post-notification consents issued for works to be undertaken within a number of the RHAs, and this information resulted in minor changes to the record forms for 9 Carrington Street, which is in the Church Property Trustees St Albans RHA, and also 2 McMillan Avenue, which is in the McMillan Avenue RHA, but did not cause me to change the rating of any of the properties concerned. Turning to Dr. Harding's evidence on the McMillan Avenue RHA, there is nothing in Dr. Harding's evidence that alters my identification and assessment of the RHA. Dr. Harding discusses heritage character areas and raises concerns with the character, amenity, planning provisions in Kashmir that are not heritage issues arising from PC13. In response to Dr. Harding's statement, I can confirm that the McMillan Avenue RHA is indeed predicated on John McMillan Brown's 1908 subdivision, and that it constitutes a portion of McMillan Avenue, the full extent of which is fully encompassed by Character Area 3. This character area also includes parts of Hackthorne Road and Dyers Pass Road. In my evidence at paragraph 95, I refer to PC14's proposed Kashmir residential character area, and I'm now aware that character area 3 in the operative plan is solely relevant in this matter. With respect to John Brown's evidence on this CPT North St Albans RHA, there is nothing in Mr Brown's evidence in respect to the subdivision that alters my identification and assessment of the RHA. I agree with Mr Brown that historic heritage and amenity or character should not be conflated. My heritage report for each RHA describes how the area meets the criteria for historic heritage as they are specified in, as I've just referred, Appendix 9.3.7.1 of the Operative District Plan. Consistent with his view on the appropriateness of a site-by-site analysis for RHAs, I note that this work was carried out, as can be seen in the site records for all properties located within each RHA. I remain of the opinion that strong evidence has in fact been provided by the Council in support of all the RHAs that are proposed for scheduling as part of PC13. I remain of the opinion that both Melbourne Park and Rugby Park are integral to the historic narrative and heritage values of the RHA, and that removing additional houses from the RHA as a whole would undermine its historic authenticity. Recreational use of part of the CPT property that was subdivided in 1923 predates the residential development of the area by over 50 years. And as the RHA report describes, the twin parks, Melbourne and Rugby, created a more desirable recreation space within the CPT's overall land holdings, rather than surveying a number of small pocket parks each time they undertook a subdivision. And that's in the RHA report.
So the parks of combination serve that purpose. So they have, we refer to Rugby Park and Melbourne Park as distinguishable. but the combination of the two, irrespective of the way there might be differences historically around their value or significance in relation to the RHA, it's the two in unison that have relevance.
Yes, so the CPT presented to the council the argument, if you will, or the position back in 1923, that it was better that they subdivide a large open space rather than for their multiple land holdings throughout Christchurch present little pocket parks for every single little subdivision. So that was actually part of the development or the design of this subdivision. And then they offered the park in two parts. The first part, Melbourne Park, was bought by the council. They declined to buy the other half, which would have given us a unified open space. And consequently, the Canterbury Rugby Football Union purchased the other half of the park. So that is when it split into two separate ownerships. But its origins were as a large open space that the CPT said to the council, you should agree to this because this is a better amenity we're providing than having a pocket park in all of our many land holdings, our endowment lands throughout Christchurch.
It's one of the submissions before us would affect that unison, if you like, in terms of taking away Rugby Park, for example. So the significance of that is, as you've described, in terms of where its origins lie as a unified package.
Yes.
Yeah.
And that is why I remain of the view that both the twin parks, as I'm now calling them, that they are both integral to the historic heritage value of this RHA. But they do happen to be in separate ownership on separate land pieces.
Yeah. We'll take back to paragraph 12, where you talk about individual powers from the RHA as a whole removal.
It's at the very top. It's at the very top of page 4.
So those individual houses, obviously, not all houses of the RHA are up for grabs, if you like, through submissions necessarily. So we've got the Rugby Football Union identified 2 of those properties. Is your comment in relation to your houses generic for any removal houses from that RHA or specific to those 2?
No, it's generic. And in my statement of evidence, I refer to it also. There was a submission that RHA should only be constituted of defining and contributory, and it probably was in relation to Littleton. Yes, it's at paragraph 87 of my primary evidence.
Okay, so there's scope conceivably. Was that specific only to one RHA or was it generic as well? I don't know.
So that was specifically in terms of the Littleton RHA, and the submitter requested that only defining and contributory properties be included. And then, so that's on quite a wide scale. On a narrow scale, there were requests for those 2.
Yeah.
In the case of the RHA, there were requests for the 2 Melbourne Street properties to be removed.
The answer to my question was it specific to 2 or was it generic? It's generic.
So just before we move on, and just so I'm sort of understanding your point in terms of the parks and their timing, etc. I'll put it in my terms, not planning terms, but I almost got the impression from the evidence for the Rugby Football Union that there was a break in the, what we'd call in law, a break in the chain of causation or something, that there wasn't that direct connection between the parks and the residential subdivision. And that the comments that you've been making now in your summary and in discussions, they're all addressing that point primarily.
Yeah, so I dispute that. I think it's a matter of fact that the Anglican Church Property Trustees undertook a subdivision in 1923 that created what I've identified as the RHA. The purpose of subdivision typically is to then sell those properties. So the position put forward by Rugby Football Union is, well, that the church property trustees then left the field. But obviously that's what you do when you're a subdivider, is you subdivide and then things are sold. So I don't agree with Mr. Brown and his characterisation that that is a sort of a break in the chain that is pertinent to the assessment of heritage values in this case. So I'm in the middle of paragraph 13.
Yeah, sorry.
That's my fault too. So I'd started that, yes, and quoted that the CPT had said that it would be better to have more desirable, larger recreation space rather than lots of little pocket parks that you could play rugby on, presumably. I therefore do not agree with Mr. Brown's contention at his paragraph 27.6 that the contextual association of the recreational open space is too broad as to lack specific relevance to the 1923 submission. Furthermore, I do not consider that the absence of an overt association between Rugby Park and the CPT after 1926 can be characterised, as it appears to have been by Mr. Brown, as evidence that the park is not integral to the heritage values of the RHA. That the land comprising the RHA was once held by the CPT cannot be disputed, given the land tenure history of the area. And I do not consider that the broader community use of Melbourne and Rugby Park since the mid-1920s is evidence in and of itself of there being no connection between the recreational amenity provided by the parks and the people who lived and live in the RHA. To put that in a kind of more simple way, I haven't conducted the exhaustive research that you would need to work out how many people who lived in Gossip Street, for example, played on Rugby Park, were members of the RFU, sent their kids to the Scout Den, walked their dog on Melbourne Park on any given day. I suspect that research would be, it's certainly doable, be quite expensive for the council, but there would be those connections, I'm sure, that would be made. I cannot comment about what Mr. Brown would consider a compelling rationale for the RHA as a whole or its inclusion of Rugby Park in particular, but note that he acknowledges that in his evidence that the general RHA methodology adopted by council aligns with the Canterbury Regional Policy Statement. As acknowledged in the RHA report, the bipartite park is zoned open space metropolitan facilities and open space community parks, and inclusion of the RHA within the district plan will make no change to these underlying zonings. In preparing my statement of evidence, I reviewed the houses that sit in 12 Melbourne Street and remain of the view that they merit a defining rating on the basis that they, and here I quote from the definition, defining rating, that they establish the historic heritage values of the heritage area and retain a level of authenticity and integrity sufficient to demonstrate these values. And I'll just note that Mr. Brown sometimes mistakenly refers to 10 and 12 Melbourne Street in the main body of his statement of evidence. Turning to Mr. Joel's evidence, there is nothing arising from Mr. Joel's evidence that alters my opinion. However, in reviewing Mr. Joel's evidence, I did identify an error I had made in preparing a combined record form for Rugby and Melbourne Parks. And to remedy that oversight, given that each park now has a different owner and a separate legal description, I've prepared two separate record forms which are appended, as you can see, to the summary statement. My conclusion is nothing has altered my substantive view on matters pertaining to the RSAs or the specified individual items to which I was asked to comment since I prepared my statement of evidence. And furthermore, I consider that the reports and individual record forms for properties within each RHA are as accurate as they can be, as about 5 o'clock last Friday night, at this time. And if I may, there was just one comment that I thought I might contribute to the discussion about the setting that was raised, because that's germane to the assessment of the items that I've reviewed for council. I would just draw the panel's attention to the fact that the RMA definition of historic heritage runs through historic places, areas, structures, and then its last clause is and surroundings.
Yeah.
And so in my experience and in my opinion, the council identifies settings in order to give effect to that part of address that aspect of the RMA definition of historic heritage. Forgive me for piping in about that.
Thank you. Right. Anyway, let's check.
In terms of the distinction bit of two properties, it's in, well, but the distinction that Mr. Brown had in terms of condition and presentation, can you comment on that?
In general terms, the current condition of a building is not germane to whether it meets the criteria for heritage significance. And I appreciate there's been quite a lot of discussion about that already today. If a building is clearly in such a ruinous state that it no longer embodies significant heritage value, then it won't meet the criteria. But if it needs a paint, or the gutters have grass, they've got lots of grass in them, that is not going to alter that assessment within those four kind of defining contributory, neutral, intrusive kind of categories or ratings for the RHAs.
So I'm taking you to paragraph 25, 26 of your evidence, where you make reference to the RPS policy, which does talk about the potential of significant historic heritage areas, etc. So there's a qualifier. It's not in the same terms as section 6F. It's a different set of words. One of those differences is it introduces the concept of significance, which presumably, this is my question, in your view, does that give justification to the nuance around why some areas may qualify against certain criteria, why others may not? That's really around determining significance.
Yes, and that you pointed to, that's the big kind of problem, if you like, with section 6 and the associated wordage in the RMA is that word significance is missing. So if you read the RMA, it says physical and natural resources that embody New Zealand's history and cultures. Well, that's jolly well everywhere. Significance assessment is absolutely fundamental to the identification and assessment of resources that should be protected under the Act and are scheduled. So the RPS in this case is sort of fixing that problem before it gets to the territorial authority level. I haven't memorised all the RPSs in the country, but some RPSs don't do that job for councils, so then councils have to insert that key
And I
term.
think I picked that up in the section 32 anyway, that that's a rationale for why there's a distinction able to be drawn around some things which may be close or in the eyes of others might be thought to qualify, and those that have been identified too, is around a significance appraisal, if you like.
Yeah, and I think that's fundamental to distinguishing between Section 6 protection of heritage and identifying Section 7 amenity, which typically gets talked about as character.
Thank you. paragraphs 31, 32, where you make reference to HZPT's historic area listings. Sorry, I'll let you take it into
Oh, sorry.
31 of your initial, we rightly observe that there's a listing opportunity through independent process, and that's occurred. There are those that exist within Christchurch properties that have been so listed.
Yeah.
What's the desirability, or in fact the necessity, for additionally identifying and protecting those items where they're already listed by Heritage New Zealand?
It's precisely because Heritage New Zealand listing doesn't kind of endow protection.
Right, it's an identification tool, not a controlling tool. Is that one of you? Yeah, okay. Sorry, some of these questions might sound very obvious.
That one, it's amazing how often.
I just want to be sure that that's why you.
Commissioner Lutz would know that it's amazing how often you've got to start with that question before you can have any kind of conversation in this space. There's a great.
That wasn't my motivation, but it's helpful to hear your answer.
There's a lot of confusion about that.
So it's relevant for obviously informing you considerations, but it doesn't generate an activity status or anything that you.
No, and listing by Heritage New Zealand obviously takes place under their Act, which they have different criteria. We're in a barrier space, that is the generator of the kind of work I do for councils.
Yep.
Can I just go back to Melbourne and the rugby club? In general, while I understand why you have actually included the parks, your rationale, in general, how far are open spaces and the amenities around residential areas included in those residential areas, and what's the criteria? What are the thresholds? Where do you include parks and where are parks not included? Because, for example, we have the example at Chester Street, yeah, where there is a park in the middle, and we had submitters to say, that's integral because that is where the whole community works from, both sides. Where are the differences? Could you elaborate on that for me?
There are two kinds of RHAs that have been proposed through PC19. There are the ones like Macmillan Avenue, the Church Property Trustees, North St Albans, which go back to a single subdivision plan, which is the kind of, and in the case of Macmillan Avenue, it's the 1908 subdivision plan by John Macmillan Brown. And those subdivision plans create a boundary of a historic nature that then you work against, if you like, or you work with in terms of then assessing the identifying whether there's a heritage area, a potential heritage area, and then working through the assessment criteria. In the case of Chester Street East and the Innocent West RHAs, for example, those aren't pinned to individual survey plans. They're part of the sort of the kind of fundamental kind of historic colonial development of the central city in those two cases. In that case, it's less clear cut where the boundaries are because you haven't got that foundational historic survey plan. But you have got, in both cases, you have got the physical resource on the ground. And so in the case of Chester Street East, for example, the park, which is called Chesterfields, forms a natural boundary at the eastern part, and it's the top end there of the eastern portion of that RHA, which is also happily marries up with Dawson Street, which was once upon a time a single land parcel, which was then a private lane and then became a public road. So the inclusion of open space with all of the RHAs is always pertinent to them individually, because that's the nature of historic heritage, is that it is going to be on a case-by-case individual basis, as opposed to lovely streets of pillars or North Shore, for example, which is, you know, the boundary for that character area is where the pillars run out. And those open spaces, to my mind, need to be integral to that historic heritage kind of narrative in order for them to be included. And with Chester Street East, one of the things that is very strong about that heritage area is that it has a lot of community support and appreciation, which goes to how you assess the cultural heritage values of the place. If you know that the community kind of comes together in that park, host civilians and things like that. I hope that's answered your question.
That makes it clear. In terms of the assessment for defining buildings or contributing buildings, with regards going back to Melbourne Street, in that case, you've said they are integral to the, you know, to the value of the area. Has that level of modification to a place consistently been applied to other areas as well, or is that more a case-by-case assessment again?
No, I've certainly tried to be as consistent as possible, because the objective, the policy, the rules are at that level of, here is this new entity for this particular plan, a residential heritage area. And I think it's absolutely vital that the same rating kind of methodology has been applied across each area, as much as can be done in a human professional context that doesn't involve ChatGPT or any other some kind of scientific formula that very often people want, but which is just not applicable in this kind of space.
Yeah, I'm sure I will come back to that with individual areas later, but
I've got while we're at Chester Street, can I explore your thinking around the fire service site, which, correct me if I'm wrong, but originally fully included, largely included, now a recommendation to reduce that identification to a feet frontage area. A couple of questions around that. First one being, you explained to me the necessity for the frontage area to remain, if you like, as what that contributes. And secondly, related to that is, given what can happen to that vegetative frontage, as I understand it, as a permitted activity, and this may be better directed at Ms. Dixon, and I'll probably ask the same question, but given what can happen and what I understand can happen by permitted activity status, what's your thoughts on that looking ahead in terms of the ongoing contribution that vegetational frontage may or may not make? So it's a long-winded two questions, but I'm interested in exploring why it's important to retain the frontage if we're removing the rest of the site, or propose to remove the rest of the site from the heritage area. And also in the context of that, I suppose, is if you were to remove all of the site, what does that mean to the west?
Yes, well, to start with that first, that would obviously create two orphan, if you will, to the west of the Fens site, both of which are
What's defining and one's neutral?
Residential properties, one defining. And so arguably at that point, if you were to remove the Fen site property altogether, it would be the question as to whether it was legitimate to keep two orphan properties there.
What's your view?
I guess I could, given that I, provide advice and doesn't always get taken, I mean, I could live with either scenario. I mean, you could live with most things. I think it would be simpler if there was a neutral and an intrusive kind of to the west. There's still a defining house on that area. And I'm also mindful that across the road, highly concentrated area there with defining properties. And so we are talking about, it's both sides of the roadway. The church property on the very corner of Oxford Terrace and Daresbury Street, and then the Fens property, which runs through to Kilmore, are very large sites on which a lot of obviously non-residential and modern development has taken place. In looking at the Fen site, because of the submission and being on the ground, I came to the view that if there was a frontage included in the RHA, that would maintain the kind of continuum, if you will, along Chester Street East between the Dress and Chesterfield Park, but that it would also provide the council with the opportunity to manage or influence development that was immediately adjacent to the road frontage in terms of fencing, particularly, and building response, which would be sympathetic to the residential heritage of the RHA. It wouldn't be to stop Fens utilising its site, because that's a very good use of a site, fire safety, but it then becomes a matter of those, it's almost like those kind of urban design qualities that might uphold the heritage values.
So it's not so much about the contribution the existing planting might provide, not discounting that that's got some amenity value, arguably. So it's not so much that it would be undermined by the loss of that, but what you're saying is the ability to control or influence what might happen subsequently, say that were to occur through new development, that enables by bringing that frontage into the RHA, there's some control over that outcome, should that ever arise, around redevelopment of that portion of the site.
Exactly, and I think really in general terms, that is the principle behind including intrusive and neutral properties within the RHAs, because again, the Act talks about surroundings, and development on a neighbouring site, either to a heritage area or within an RHA, has the potential to undermine those heritage values. So that's where I feel that we've come to, again, it's a sort of the pragmatic real world kind of application of heritage practice and planning practice. I feel that the frontage has come to a satisfactory meeting of the property owners' issues raised in submission, and the potential for that narrow, I think we said 5 metres.
5 metres, I think. I don't quite remember.
Fill it immediately adjacent to the roadway, in which one can only ever imagine kind of probably fencing of some.
Well, the newish development almost up to the street, but I don't want controlling provision.
And I think that's the same. And this is how I've read the applications that the council's already assessed, because the RHA provisions have been live for 2 years, is that then it's about to what extent does a new proposed or new build maintain or possibly even enhance heritage values. And so there might be some design considerations about new build on the street, that it might run some gables, maybe breaking things up a little bit. Also not putting a solid 2 metre boundary fence, that kind of thing. But yes, it certainly, the rating was never that there were here, this was a defining property.
Okay, thank you.
And I'm just thinking out loud here, how realistic is that? I'm thinking that theoretically all of that can apply and can occur. but we're talking about a fire service site. So the only thing that will ever be built there is a fire station. That is a very functional building, and a town. In terms of the contribution that front, the fire station will not have a fence, because they need to get out before without that. So I'm just realistically thinking, talking about that practicality that you have just been mentioning. How realistic is it really that those 5 metres make any difference?
I think actually in this particular case it is quite realistic, because you're never going to have a fire engine coming out to Chester Street East, because it will take you, I doubt the truck could actually turn the corner. So the fire station kind of is on Kilmore Street.
Yeah.
So
it's back of house.
It's back of house. It's been back of house for a very long time. I think realistically you've got some portacom kind of temporary kind of classroom almost style buildings there at the moment. I think it's going to be admin, possibly some staff accommodation, possibly some things that are quite compatible with the residential kind of aspect. But unless kind of we were all told differently, I think the chances of any kind of egress by the fire station out onto Chester Street would, I think that is quite unrealistic, that scenario, in this, given the land, the way the roads work. Yeah.
For the fire trucks, this might be the one becoming an in and out for the people's cars.
Yeah.
Yep. Thanks for that.
But you carry on.
I've got
While you're talking,
Well, I think that I'll just keep on going. Yeah. In sequence. Let's talk about Chester Street right now. Now, go into your paragraph 100 in your sheet. As a general, from a general perspective, can only be buildings that are original as designed initially be of high value. With looking at buildings that have had minor changes to them and have been graded as contributory rather than the defining. I just want to understand where's the threshold between how much modification can you do before it becomes not defining anymore?
So that is, paragraph 100. So that was in respect to the McEwan Avenue RHA, isn't it? Which has a genesis date in 1908, and then a lot of residential development subsequently as people kind of stopped holidaying on the Cashmere Hills and started living there full time. It's entirely situational as to, even though I've done my very best to be consistent about the defining contributory, those ratings are informed by what are the heritage values of that particular place. And so with McEwan Avenue, for example, there are a number of houses that are architecturally designed. So just a way of context, if an architecturally designed house from the 1960s is there, which is adding, it could be defining as much as an architecturally designed house from the 1910s, in my opinion. The level of modification is typically, I've not been concerned about the interiors of buildings. So clearly there could be quite a lot of modification that's gone on inside buildings. In terms of the exteriors, it's sort of, you do take it on a case-by-case basis of a building, and it may be, for example, that a building has had a second story added to it in a very sympathetic fashion. Or if it was a bungalow in the Heritage Property Trustee subdivision, for example, there's a lot of those 1920s, 1930s bungalows had quite high-pitched roofs that then allowed for dormers that kind of turned them into full stories rather than just a room. So to me, that wouldn't be kind of wholly determinative. I think where aluminium joinery kind of rears its ugly head out of context, then that can be a key issue. In what was the Pico-Shand RHA, a lot of those contributory ratings were predicated on original state houses with garages mushed up in the front yard. And not because, it's character, you're looking at the streetscape, you're just starting to be obsessed with what you can see from the road, but because the design ethos of state housing was to create those amenity kind of qualities, openness to the street. So as soon as you smush a garage, great 2-car total span garage, you've undermined the authenticity, if you will, of the property. So it is, I'm sorry, that's a wee bit of a vague answer. It is case by case. And it is iterative because you have to have an idea about what are the heritage values under those criteria, but then you've got to look at the resource and see what that tells you, and then you've got to go back to your criteria. So which is also something that kind of annoys people sometimes because it feels like that's not properly scientific, but assessing value can't be.
Yeah. With that in mind, that it is case by case, and that modifications can be done, I think is a reason to downgrade. Can you talk me through your paragraph 101 and your decisions there? Because you have downgraded a building to contributory because it has been considerably modified, but the modification was done very early on. So that building has been in that state for 100 years or more. But it's still not, because it's modified, it's still not original. It has been only a contributory building.
Right. I'm sorry if 101, I'm sorry if I've caused confusion. So the house, I believe, dates to the 1890s. The modifications look like interwar. There's stucco, cement plaster finish. There are bungalow windows. So the modifications, yes, they're still quite old, but they're not, just in case there was any confusion there. Again, it's that integrity and authenticity that, and I guess to some extent it comes down to sometimes modifications are much more sympathetic to the kind of inherent architectural quality of a building than in other cases. So in that particular case, Shelley Forbes is later 19th century kind of artisan workers heritage area. And those very small timber framed and weatherboard clad buildings with corrugated metal on rooms. And so then when you start to have a departure from that, then it's about that, whether they still embody sufficiently that value in terms of that level of modification. And so in that particular case, the actual house itself has, it's retained largely its envelope, its footprint, but you can't decipher the cladding materials aren't authentic, the windows aren't authentic, or synthetic. It's a kind of bungalow era update, and that would be, to my mind, I think when this all hits the planning space, that's why I think it makes good sense for the defining and contributory buildings then to be kind of clustered together to a large degree, because you can then have that kind of more nuanced kind of conversation when it comes down to a particular consent application. And so there are groupings of defining and contributory, neutral and intrusive on the basis that a consent application that says for a contributory, we want to put on all the stucco, right? It's an exterior alteration. It will be highly visible from the street. If I was in the room, I would be saying, fantastic, bravo, love and kisses from your local council. You're really going to be upholding those heritage values.
So what I'm hearing there, and again, it's something we'll probably explore with Ms. Dixon a bit further, is whilst we've got a four-tier nuanced categorisation, when it comes to the activity status that falls out of that, there's a clustering that occurs. So whether there's a distinction to be made between, say, defining or contributory in the wash, that might, from an activity status point of view, when someone's having to apply to do something, that actually may not be material.
I think so, but I think
I know that because I've read it all, but
I think on the other hand, I would suggest, and this is why I talk a little bit about Hamilton City Council's Plan Change 9 areas, is that they don't make any statement as to defining contributory, non-contributory, anything. And so I'm over 24 now, heritage impact assessments for those, and it puts the onus on the owner and their heritage consultant to write the story for the council of how their house contributes to the heritage area, and then say, now that I've told you all about my house and how it fits within the area, now please give me a consent for taking off stucco or something like that. So that's why I've put in my evidence that I believe that if one or all of these RHAs are adopted, I think that four-tier kind of rating then becomes a tool for implementation and for assisting owners to navigate the process, and for consent planners to kind of understand the risks they're dealing with, which I think will be helpful for owners based on my experience in Hamilton.
Staying with Shelley Forbes, I think that was the area where I personally had the greatest issues with understanding what I found on the plan. First of all, I think there's an error in there, which is at number 18, ABCD, they are green, which I understand to be contributing, but in your schedule, they are intrinsic.
Yes.
So explain.
So you're absolutely correct that is a mapping error. Yes, and they should. So
Intrusive.
and I'd even, just so you know, I'd even written intrusive.
We were standing there and looking at
Thank
it, thinking, we cannot understand things.
It's
And now we know why.
even to the untrained eye, that looked like an anomaly.
Yes. Yes. Yeah. No, absolutely. That's a mapping error. Thank you.
On the other side of the road, there is number 25, which has been classified as neutral. And when we stood there, it was a very well maintained, fairly intact building, historic building. I could not quite get my head around how this is neutral, whereas at number 19, it's intrusive. And then number 79 again is neutral. I could not spot the difference, if you want, in terms, and that's what I was earlier asking about the thresholds and where do you draw the line, because that was not obvious to me.
So I will, if I may, I will check that because I don't have all of that.
Yeah, sure.
That's fine.
So that was number 25.
Number 25.
And it's currently, it's mapped as neutral.
Neutral, yeah. Then we have number 19, which is intrusive, and then we have 17A, which is again neutral. And yeah, so just to understand where the difference of thresholds are and why they are. Now, in your appendix 2 for your evidence of G, we have the different RHAs, and then you have actually footnotes and reasons for change in there. And what I don't quite have my head around is there is a reason for change is because it's new built on a vacant site. So that's neutral, for example, in Northern Albans. Then we have page over at 13 Exeter Street and at 29 Dublin Street. We have a vacant site on which a modified bay villa was demolished. That's neutral. And then we have a square plan villa on the site demolished, and which is also an undeveloped site, and that's intrusive. Can you explain to me where the difference once again is between these things?
I will just have to check the record forms. I'm going to assume from memory that 29 Dublin has been rebuilt.
So they're no longer a vacant site, there's a new development.
One of the challenges with, and I think I've pointed that out in my evidence, is that Littleton, all these things end up with exceptions. So on the whole, within the Christchurch City, a vacant site caused by demolition, particularly post-quake, is typically rated intrusive because it breaks the continuity of a residential environment that pre-existed.
So no developed site as a consequence of that. Yep.
Yes. In Littleton, it's a bit different because you have so many different viewpoints, as you will appreciate having been there. Because in the Christchurch RHAs, you're standing on the street in terms of the visual and the way that you appreciate the house, the way that you understand its architectural presence, and so on. Whereas in Littleton, a vacant site can be neutral rather than intrusive because of the topography of the town. And I know that's an inconsistency. I think it's valid from my point of view, but it is to do with how you appreciate the topography of Littleton and the visibility of properties, either if you're on Grassy Terrace or if you're looking from one side of the valley, if you're looking from St David Street over the port towards the hill. Sometimes properties have a higher visibility some distance away. So if I may, I will check those two particular cases.
They were just an example. There was more further down, but yes, that's right.
But typically, as you can see with Wigram, where I've assessed those, neutral tends to be, particularly in Christchurch City, tends to be new residential build, which maintains that residential heritage kind of value generically, but is not, in that case with Wigram, it's not staff housing.
But how does that then relate? And I come back to the Shelley Forbes area, that the Forbes area new builds are intrusive. Are they particularly bad or?
Well, because they're 2-storey and there's 4 of them in a heritage area which is predicated on small single family dwellings on sites. So to my mind, that, as you could see from being there, it's an anomaly, is that it kind of stands out more than it might in some of the other residential heritage areas because of its typology, its design, and so on. And I, as I say, I always try and go back to those defining contributory kind of neutral intrusive ratings to kind of double check myself. And certainly the desire and the effort has been to make them wholly consistent within the RHA, and then to my best of my ability, even though every RHA is an individual, is to be consistent across all of the RHAs. But I'm happy to check all of those to provide you with more commentary.
Could you please then put on that list to check the Inglefield Avondale residential? There is what is that? I think it's number 6 or number 10, the very southeast corner. There is one place that has been highly modified, that has been rated as contributory, and it stands out. It's one of those that you stand there and you think, oops.
I just get you oh no, that would be the best piece of paper to give you actually. Could I just get you to scribble on that one, please, Commissioner, and then I will.
That's the one I'm talking about.
Bottom right.
Bottom right, okay.
Sorry, when I said bottom.
Hanmer Street, and I will look at them, but certainly. Thank you for that.
In relation to that, to be clear there, I understand, and you correct me if I'm wrong, please. In that area, the Avonside Drive properties have only been assessed from their front, Avonside Drive character or heritage value. The Louisa Chandler Lane was not separately assessed to contribute to that area because it was a right of way in the previously, as I understand, but now it's a street where people walk up, and it's a street that actually does have, at least from our understanding, walking around there, does have an effect on the authenticity or intactness of that area as a RHA. And there's just one thing that stood out for us in number 14. 14 Avonside. The back of that has a large, you can't see the house, it's just an enormously huge garage. And we were standing there thinking, but that's exactly what shouldn't be there. Or this is exactly what typically, and you've been saying that earlier today, those big garages in the front, that is typically a tick in the bad box. So how far has that line been part of the assessment?
Well, I definitely, in assessing the area, on all up and down Louisa Chandler, but as you say, the object, if you will, of those houses is to look to the north towards the river, and so in that case, big blobby garages are at the back if they're away from Avonside, even though I fully appreciate that they're at the front if you're looking at Louisa Chandler.
It's a consequence of the two frontages.
Yeah.
It is, and you get similar things going on. The lanes and walkways and things in Littleton that there's public kind of access points. It's the way that those houses were built, which is typical. I mean, historically, people are building to view the light, in those cases. So yes, absolutely did look at Louisa Chandler, and in that case, my concerns or reservations about great big garages were kind of set aside. I would say largely because it's the Avonside Drive, and you can appreciate, I think, walking around there, how you've got a mixed character. Those Avonside properties were always larger, some architects involved, were kind of higher spec houses than you have in those little cottage streets. And that is part of its kind of historic quality, as opposed to you don't get the big houses in Shelley Walks, for example.
Very last one. In the City West, you have provided us with some update in terms of the YMCA buildings that have been pulled down and new buildings being built, so you have taken that out. Can you talk me through how the side of the Ronald McDonald House, which is on the opposite end,
Yes.
why that is included as intrusive, because it's a rather large site. It's actually, if you look at it, it would make up maybe 3 or 4 sites really. But what's the rationale to keep that in?
Yeah, I can see how, yeah, as soon as you start chipping away at corners, then you, clearly the desire, yeah, you could argue that it is problematic that you have an intrusive site at the end. On the other hand, what started as the Inner West residential heritage area was 3 city blocks plus the north side of Armour Street. And because that is the nature of the colonial plan of the city of Christchurch. And to my mind, there has to be a very strong reason to void that kind of foundational subdivision or survey aspect. What was the Christchurch Girls High site, which was the first subdivision submission that comes off because all of those buildings have been demolished and then and so on. So that that came out. In the time it's taken this process to work through, since I assessed this area initially, there was a defining house on the Fisher Street frontage of the greater YMCA site, which was removed, and then there's all entirely new build there. So my recommendation is along the lines of I guess I'm trying to have a Bobbish way of said it, for consistency, it could be removed, a la the former Christchurch Girls High site. But I still remain of the view, which I present in my evidence, that there are such high heritage contextual values in that part of Christchurch on Rolleston Avenue, adjacent to the Botanic Gardens, proximity to the Arts Centre, the museum and so on. I'm still of the view that any future development should be cognizant of those. I guess it's a question of what kind of lifespan buildings have. So I take your point that having an intrusive site of quite large scale at the edge of an RHA is possibly problematic, but fundamentally I think that there has to be a very strong case for departing from that colonial grid, because there are potentially very strong archaeological values there, if nothing else.
Thanks for that. And that was me. Sorry for taking
I think we've got a couple more, and then we'll do some housekeeping checks, because I'm just a little bit concerned about our timetable with Stickson's going to hate what I have to say, but we'll deal with that. We have a couple more questions.
Oh, there were only a couple. One is whether you had any comment in terms of the activity status in terms of upgrades, double glazing, those sorts of matters. In terms of that.
Yeah, I've had some experience with that in respect to Nelson, because I've lived in Nelson. And that community is very, very proactive about always wanting to actually encourage and facilitate any sustainability measure, whether it's flood proofing or solar panels, double glazing. I think that certainly for scheduled items, I think there's some potential for solar panels in particular to really put things up from a visual point of view and the integrity of the architecture. But fundamentally, anything that allows a building, whether it's in the heritage area or if it's individually scheduled, to maintain its use is good for heritage. And in this case, we're talking about residential heritage areas. So anything that allows the residential use of those buildings to be maintained and enhanced even if it comes with a little bit of visual clutter, is highly preferable. Because potentially the alternative is that you get a lot of conversion of residential property into commercial, and then you hollow out, you lose the underpinning kind of historic value of these being houses for people to live in.
Thank you. That's pushing on that. Just a couple of things in terms of back to Chester Street, but just the connection. And just a couple of questions I had. Yeah, the I understand the former warehouse wasn't it for Ward's Brewery? That's the one that's been
Yes.
converted into, yeah. So why do you treat that as neutral?
So that's outside the heritage area.
Oh, so it's outside, but okay. So have you assessed that at all? It's raising submissions, that building in terms of.
Yes, so there were a lot of submissions in support of the RHA being extended the full length of Chester Street East. And my position was that that very corner site, which was the Ward's Brewery, is a scheduled item. And so there is appropriate protection of heritage values there. And then between Ward's Brewery on the corner of Fitzgerald and Chester Street East, between there and Chesterfields and Dawson Street, there's been so much redevelopment that the area, it no longer embodies those historic heritage values.
All right, what's the lack of connection? You talk about a lack of connection of Chester Street to the other side of Fitzgerald Ave, basically. Is that the break?
Oh yes, so there are also submissions wanting it to be kind of joined up.
Yeah.
And essentially there's two different kind of development stories and histories there. I mean, everything is connected to everything in terms of the residential development of the city. But in order for there to be a single RHA that went from Chester East right through to Hamner and incorporate, the Inglefield Avonville, to my mind, there would need to be a shared development history and heritage values, and I don't think that is present.
And what about in terms of the extension to Chester Street East, just to the west side of Fitzgerald Ave?
And no, again, there's so much new build. I took the point and appreciated the submissions that pointed to the community recognition and value of all of Chester Street East, but those assessment criteria need to kind of work in tandem. So just saying that there is a high level of kind of cultural or community heritage value is not enough to meet the criteria, in my opinion.
And that's where you've said, was it in that context that you talked about the Chester Street RHA and the Inglefield Avonville RHA having nothing but physical connection other than physical proximity?
Yes, and some general historic kind of commonalities in terms of that part of the city, and being close to the river and good place to make beer, but not enough.
That was all I had.
All right. Sorry. Thank you for your time and thank you for your submission today. I did settle some housekeeping. I want to just take stock of where we're at. According to the schedule, we were going to give Ms. Dixon this afternoon. Have an afternoon tea break. We've got a representation of the Zephyr Yard on a couple of Daresbury and Antonio. Now, availability, I'm minded to try and bring you in this afternoon. And hopefully complete that.
So if I can indicate, I mucked up the hearing schedule originally because I had a hearing for tomorrow and Wednesday.
Right.
That is not happening now, so I do have a bit more flexibility. I do, however, and I'd signal to Mr. Pizzi, have a number of witnesses turning up this afternoon.
Yeah.
Just to update valuation, just to update dollar information that was given at PC 14.
Right.
So but I could leave the legal stuff if you needed me to come back tomorrow, but if we could just hear from those witnesses briefly on those update on those valuations.
Well, our options seem to be we divide you.
Yeah.
Or we try and complete you today at the expense of the dismissal.
Well, how flexible are you tomorrow, Glenda?
You got.
I always expected that to happen.
We've lived up to expectations, that's reassuring. That might be a clear cut, if you know what I mean. If you're confident, we were scheduled to go through at 5:30. It'd be nice to have a bit of a break before we start.
No, I'm happy. I'm happy to keep going as long as you can keep going. If you want to get me done and out of the way today. Sure you would.
Yeah, my inclination is to have a short break now, maybe bring your collective forward, and hopefully complete that today. And maybe entertain.
And you mean you may have time for Glenda if I.
Well, if you don't take an hour and a half, we should go 5:30. We could.
Well, I suspect that I may not. When I gave that time estimate,
right.
I hadn't been aware that Mr. Pizzi was going to file the memorandum that he had.
Right. Okay.
Has, but I didn't have Antonio call as a client then.
Correct.
So,
going dead lost.
Yeah, going dead lost.
Yeah.
But I'm pretty confident. So the witnesses that I have, and I had discussed with Mr. Pizzi, notwithstanding I haven't actually filed any evidence.
Yeah.
What is attached to Mr. Cleese's evidence is evaluation.
Yeah. And
then the valuer is just going to come along and go, well, it's changed by X%. So they're going to be 5 minutes each.
Yeah.
In fact, here they are now.
Right, well,
That's, yeah.
I don't know what you think, but.
So I don't think I will be an hour and a half.
Okay, well, let's take a 10-minute break and then kick off with yourselves, your line up and get through that in time to start or the things we'll do that.
I'm sorry.
Otherwise we'll roll you. I mean, entertaining the idea of starting a little bit earlier tomorrow too, so we can explore that bit of the day. But let's approach from the back.
What I might do just to help, I might even run through the updates and evaluations first and then come to my legal second, because I can actually come back tomorrow if needed.
I'm confident if you think you can get through by 5:30, that's fine. That's my preference. Rather than split you, I'd rather just fix it.
That's fine.
Greatest respect.
Oh, yeah.
Right, but let's have a 10-minute break. I certainly do. we have enough seats. Good, okay. So we're going to hear you, as I understand, in respect of two properties in particular, Daresbury and Antonio. Yeah, just conscious that we've received some pre-circulated evidence, but not all.
Yes. And I am going to ask for a little bit. So I have to.
We're minded to give you a little bit.
Yes, I'll
With
do
a qualifier. Okay, if we determine, having heard it, we don't know what we're going to hear it from, but if there's any consideration to the result, we may choose to consider it differently. So just put that qualifier out.
So with Daresbury, we did file some evidence from Mr. Please, and he's going to give evidence. He did attach all of the evidence from PC14. So what the witnesses for Daresbury are doing are just updating that evidence in terms of dollars. So the witnesses are all there. It's just can't remember what date that evidence was, but it's to bring us to the present day in terms of dollars.
Yeah, as I say, just conscious that I'll pay it's just right.
So if we can perhaps just hear it first and then we can decide. Actually, Brent, have you got copies? Sorry.
I've got a copy of James Smith.
So I am conscious that I did say to Mr. Pizzi I was going to bring updated valuation, updated dollar evidence, but he hasn't actually seen it, so he may have a view. So what I'll do is I'll do my legal submissions last because I'm conscious of time, and I'll get through these witnesses first, and then we'll have a little bit of a range sheet from where we're up to. And I'm just going to deal with the update to Daresbury first. So if we just take all of the evidence that was attached to Mr. The evidence is read, and we're going to update you from there. And I think each witness will be 5 minutes.
So who are we hearing from?
We are hearing from James Milne, who is the owner of Daresbury, who gave evidence at PC14. We are hearing from Mr. Harrison, who was the QS, who gave evidence at PC14, and he's just got a spreadsheet with his updated numbers. And we're hearing from Mr. Shoulders, who was the valuer, to update his evaluation given in relation to PC14. And then Mr. Please is going to answer any questions that you've got. In relation to Antonio Hall, I don't think there's any evidence filed by anybody, but I have one person who wishes to have 5 minutes to give you a dollar figure. So we have two representatives here. We have Chris Scott and Ben Bridge. Ben Bridge and Chris Scott are Mainland Capital Limited, and they are assisting the owner of Antonio Hall to sell or develop the property. Is that correct? Yes. And they just wish to give you a dollar number.
Okay, so we'll grant.
Oh, and Mr. Phillips is he's their planner, and he's got about 2 points to make, don't you, Jeremy?
Yep.
Yes.
In relation to
Antonio Hall, and we're just talking. We're not reinventing the wheel. It's just bringing you up to date on the current situation.
Well.
And
Yeah.
5 minutes each.
Restating the qualifier, having not knowing what we're receiving, we'll reserve the position on whether we think anyone might be disadvantaged. I appreciate that you've given Mr. Pizzi a heads up, but equally, timing. We've got through till 5:30 in the schedule. Are you confident we'll get?
Yes, I am pretty
Longitude of 5 minutes doesn't add up to an hour and a half, I don't think.
No, and I've got my legal submissions, but I can give them to you to read at your leisure if you don't want to read them out. So we'll just see. We'll get through the witnesses and then see where we're up to.
I would prefer if you read them out, but
Okay.
we'll see how we're tracking.
And I can actually come back tomorrow, Thursday now, because my hearing fell over. So I've actually got time to come back at least to do those.
Yeah, it's our intention to try and get through today, obviously.
Yeah, it's easiest for everybody. And
There's less pressure on tomorrow, which is already.
under some pressure anyway, particularly given this is something.
Well, all of my witnesses have heard their 5 minute warning.
Is Mr. Mill filed evidence?
No, his evidence is attached to Mr. Cleese. He gave evidence at PC14, and Mr. Cleese has
So
attached.
that is attached to Mr. Cleese's evidence.
Yes, yes.
I'll just summarise my email.
Can you
Shorter.
tell me what can you tell me what attachment that was?
Sorry.
Because it wasn't expert evidence, it's just James.
Oh, okay, sorry. Mr. Cleese said he may not have attached it. It is PC14 evidence, though. He said it because he only attached the expert stuff.
Yeah, I feel like
Yeah, sorry about that. That's my
Right, okay. Well, we have,
Unless the council officers attached it, they seem to have attached, but anyway.
well, we've got access to all of the PC40 units, should we need to, so.
Yeah. So Mr. Milne's the owner of Daresbury. And one thing I will just say in advance is that he was very disappointed that the PC14 commissioners did not take up his invitation to a site visit. So he will be extending the invitation to you.
It's a good point. We've been to a lot of these sites, but we haven't been to this particular one. Now, there's obviously perhaps some impediments to us freely wandering in and around. So
Can arrange that?
if we,
Yeah.
it's quite possible, and I don't know the timing of that, but if we've got a point of contact, we could be through the council officers.
Yeah, that makes nice sense.
And they've got the usual rules that Ms. Apriable knows fully in terms of what happens on the site visit.
I just want to say we'd appreciate it if you would, both sites, because the PC14 commissioners didn't.
Okay, well, we haven't, I won't comment for them, but we would probably like to and intend to. It's just a question of when. I'm actually overseas for a month from Friday morning, so it may not be for some time. But we'll be in contact around it. It's very probable we will want to.
Yeah, sounds good.
Okay, James, if you just read out your summary and just bear in mind it's an update and it's be quick.
Okay, so my name's James Mill. I'm the maker and director of Daresbury Limited.
You don't need to read too fast.
I purchased Daresbury House in 2018 with a clear vision to restore the historic homestead and develop the surrounding land into quality residential housing development. The purchase was made on an as-is basis with no insurance proceeds available for repairs following the earthquakes under previous ownership. Since acquiring the site, I have put in significant time, money and energy into maintaining Daresbury House, repairing leaks, securing the building and commissioning detailed structural assessments from day one. I engaged experts and explored every possible option of restoring or adaptively reusing the house, including converting it into apartments or a boutique hotel. Unfortunately, none of these options proved economically viable. I applied for Heritage grants and engaged in regular discussions with both Heritage New Zealand and the council. Despite those efforts, I was unable to secure any financial support due to the policy restrictions and the building's classification. To generate funding for restoration, I progressed a subdivision of land. My hope was that sales from these sections could be used to support the repair of the house. Unfortunately, the timing coincided with COVID-19, economic downturns and long delays in resource consent process. Ultimately, I sold sections for around 20% less than anticipated. After deducting all my development and holding costs, I made no profit. Now, I put this little table here to kind of point out a bit of an argument against Suzanne Richards' comment on, which I didn't leave a point here, but there's a comment in her that I should have used the money from stage one to help save Daresbury House. And I Richmond. Yeah, I get the point, but it's
I can probably help that. It's a comment that the landowner should be required to subdivide and use funds from subdividing the rest of the land to. And the same argument was run in relation to. Okay. I just was cross-referring to some other evidence. It was in relation to Blue Cottage. The same argument was not accepted by the independent hearings panel.
I did have that intention, but it just hasn't worked out. You know, like after the land sales, 20% less than the valuation that Mark gave me beforehand was quite realistic. I was selling the whole thing at session. And then costs and holding costs. It took almost 3 years to sell the properties down, where I kind of thought after it would go to market, it might be 6 months. The holding costs and the loss of sales kind of just killed any profit in the project, left me $1.9 million red from stage one. So that's had an impact on stage two with the Daresbury House as well. So stage one did not generate any surplus funds. I'm left with significant holding costs and no available capital to restore Daresbury House. Also explored traditional development finance options, and this is a point from my last submission that I walked out of, which I talked to you guys about. So in general, lenders allow you up to 50% lending as the LVR on land holding phase. So I could borrow 50% of the value of the property while I'm holding onto the land, while I get the development or the project underway. So then once the project is consented, I'll be able to borrow up to 65%, and that's at the top end of it, 65% of the as complete value of the project. So if I use Ford Baker's valuation on the land, and this I'd like to point out that is an unencumbered valuation. So his report, which currently with the house the way it is encumbered, but it proves my point even more that essentially the land value we're putting on it is $7.4 million excluding GST. That's unencumbered. So I could borrow 50% of that. So I could borrow $3.7 million on the land holding only. Then as part of that project, my preliminary holding costs would be 420 grand a year that money would cost me. That would include the interest on that 3.7 and the rates on the property and some other costs that go into that. So over 3 years, it's $1.26 million just on the land alone. Say, for example, then that leaves me 2.5 million that I'll be able to potentially borrow against the as complete value, which if you refer to Mark's valuation, I think he's had something like an as complete value might be at a push roughly 9.5 million, which is more than the current highest land sale in Christchurch. So the problem is restoring the house would cost significantly more, roughly $9.5 million or more. And the highest residential sale is 9.15. No prudent lender would support a project with such a large funding gap and an unproven resale value. It's just impossible to get funding for a project like this, as well as the gap and the cost of repairs compared to the value. So I've exhausted every viable option, and without substantial private capital, which I don't have, and this project is not bankable. That's why I'm now seeking to have Daresbury House delisted from the District Plan's Heritage Register. This is not a decision I've taken lightly. My family here has personal and emotional ties to Daresbury, and I remain committed to salvaging and repurposing the elements of the house within the new development. But unless the listing is removed, I cannot move forward. I respectfully ask the panel to support this request. This would then align with Christchurch City Council decision and Heritage New Zealand Archaeology Authority will be obtained.
I think it's attached to Mr. It's just received last week or the week before. Yeah.
So Heritage New Zealand has given me the authority to demolish the house.
Archaeological.
Yeah.
Archaeological Authority.
Yes, that's it.
Yeah. Okay, so delisting will allow me to progress with the site's development in a way that reflects its heritage and contributes much needed housing to Christchurch in line with the goals of PC14 and New Zealand government.
That 9.15 million highest residential sale, where was that?
That was the Rocks
Scarborough.
in Scarborough. Yeah.
I know. Yeah.
Oh, was it? Was it further up? Was it?
Yeah.
Oh, okay, yeah.
Not that property.
Wasn't the rocks there?
Oh, sorry.
Some of them were alleviates.
Scarborough. Right.
Yeah.
Okay, yeah.
Thank you. Questions?
Can you tell me about the subdivision that has been done? Just what?
Yeah, so it was a well-proportioned 6-lot subdivision coming in off Fennel Road. It was done on my old family home site that was at Ezra's house as well. I subdivided into sort of well-proportioned sites. They were kind of, there was a 800 square metre, 85 square metre, 824 square metre, a 620, 1,078 and a 1,400 square site. So it's kind of well-proportioned. It's flood management area. So there was a little bit of niggle with the subdivision with dealing with that with the council, and that's kind of what caused a lot of the delays and took a long time to get to market. It's got a railway track beside it, a stream that runs through the middle of the property, pretty idyllic.
So just back to very basics, that subdivision is not on this
No, it's sold. That's on the northern bank of the stream, that subdivision. It's completed, but it is linked by a bridge. So you can drive in off Field Road to Daresbury. And the subdivision is called Daresbury.
That may be where my confusion came from.
Yeah. It's kind of like, I've always thought that, we'll do some information board at the gate on the street, kind of detailing the history of it, be in touch with the original family that built the house. And so,
There's one from me, and perhaps even best directed to Mr. Cleese, but these numbers that you're referencing here, that's consistent with the evidence of Mr. Cleese.
yes. Yeah. They might be slightly updated from his numbers that are in his report because we've done an update since he
Mr.
wrote
Cleese can,
it.
Mr. Cleese can deal with it.
Okay.
Those updates have been done in the last 24
That's
hours.
pretty minor.
So they won't have been done at the time that
If you just identify what those differences
Yeah.
are, just as long as we're comparing
Yeah.
it.
Yeah.
Questions further from, thanks very much.
Right, you can sort out with none.
Close to 5 minutes.
Yes. Here's my longest one. So Mr. Harrison has updated the US figures he gave in PC in the spreadsheets out. So, and this is literally hot off the press. I don't think I've even read it. Stu, when did you finish it? An hour ago?
Late this morning. So the top spreadsheet you've got here is, it just talks about the repair option costs that I've come to and what roads do. Below that is the replacement.
Sorry, you can explain who Rhodes is.
Oh, the QS.
Council.
QS, okay.
So you have
Yes, and that was attached to Mr. Cleese's.
30th of September.
That top sheet just explains the repair versus the replica replacement cost.
Yeah.
And then the next two are the range between a modern high and a low build cost.
What you differentiate those?
Just a modern home versus the replica that you would.
Yeah.
What you see now is the old original homestead. So the replica is trying to replicate that as best as possible.
Yeah.
The modern one is just completely like a brand new build. There's a range there. And then the last three rows there is just the replacement replica less the repair option to give the difference between the two of us. Top right, I've got a difference between us on the repair option of 452. And then on the next sheet, that just explains where I see the gaps that get to the difference.
What's the most significant contributor there we've got?
So just briefly, we started with the mill construction estimate. Gavin had removed some items indicated in red, which he believed were part of the PNG. We then came back to some agreement about those weren't in fact part of the PNG. So we ended up adding back in a lot except for the contract works insurance, which you'll see off to the right under the difference column is excluded still. So I've got it in my column, the blue column. Gavin's column's the yellow one. Then there's some mobile and some scaffold. The scaffold I added back in. Gavin was part of the PNG. So that was excluded from the PNG. So that was added back in. Then the difference starts at the percentages for the first one was the preliminary and general. So Gavin had applied his percentage to his first subtotal, the 3.9 million, as opposed to the 4 million and the 73. So there's a slight difference there. I'd used a higher percentage, 12% versus 10, just purely because it's a complicated repair. Margins we were different on. Gavin had used 7.5, which he indicated at the time was what he was seeing in the market. I disagreed. I saw 10 in the market, still see 10 in the market, and it's a complicated repair. And then we had both agreed on contract contingencies and professional fees percentage-wise, but the difference, of course, is are being applied to different totals. Yeah. And then I agree with the method Gavin used to inflate the figures from previous numbers using the labour index and the material price index. So those calculations we both agree on, and they're just applied again to a different total. So that was the justification for the 452 difference.
Yeah. The time of PC14, what was the magnitude of the difference?
Much the same, bar the inflation would be added to it. Well, adding, get some more numbers into Gavin's estimate, then the gap obviously between the replica rebuild and the repair reduces, which becomes yeah.
Commissioner, as well as giving evidence, would it be helpful if we asked whether he's seen the summary that was prepared by Mr. Stanley?
He won't have, is that today?
Yeah.
He won't have if it's today.
It's 2-page.
Okay, well, if you-
That'd be a good time to pass it up.
Yeah, well, maybe, the commissioners can maybe ask him some questions and then we can move on to someone else, and then just keep moving, he can read it and then come back if there's anything. Is that right?
You've got copies here?
Have you got some? Nick, you want to go and get, so whose is it? Kevin's.
Yes, Gavin Stanley.
Gavin Stanley. Sorry?
Escalation has been applied.
Where's that from?
It's Gavin's. Yes.
Okay, if you want to point.
Qualify, we haven't read those summary statements ourselves yet. So we're going to come back on it, but sort of agree with what you're doing.
Yeah.
It's your time down.
Just on that, on Gavin's statement of primary evidence as well, I just noted.
You come here, sorry, I haven't been
We're
watching.
not, no, we haven't. And we haven't read the summary statement either, so we haven't got that.
Are you going to get it, or is it being taken as read?
We've got the pre-circulated evidence. We've got the summary statement today. We haven't read it.
Okay.
And we haven't asked to have Mr. Stephen, because we don't have questions. We didn't read that.
Okay, well, Mr. Harrison does have a comment on the primary evidence. He might as well
Just
do
one.
that now. So could you just orientate the commissioners on which
So-
part of the evidence?
Paragraph 20B. Gavin makes a note.
Hang on, just let them.
Sorry. Multiple piles. With the primary evidence.
Paragraph 20.
Sorry, paragraph
20. Just a correction at the end of the day.